This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why you only get what you pay for, and when a court reads the full policy, it must rule as the policy is written. And it is not nice to lie to your insurance company before buying a policy. Mark Scafella appealed the order granting Erie Insurance Company and Stanley Geho summary judgment in their underlying declaratory judgment action. In Mark Scafella v. Erie Insurance Company, a November 14, 2023 decision of the West Virginia Intermediate Court of Appeals, the West Virginia court resolved the dispute by reading the full policy. In 2017, Mr. Scafella purchased the Terra Alta property known as Country Chap Farm. The property included a residential home, a large barn with an adjacent milk house, several sheds and smaller barns, and a small country church. The underlying case arises from a fire on Scafella's real property. The insurance claim Scafella made following the fire loss did not provide the results he desired, and litigation followed. The property was insured under a homeowner's policy of insurance issued by Erie, identified as the Erie Secure Home Insurance Policy. The policy included other structures, coverage limits of $101,400 and coverage for personal property up to $380,250. The property protection section, our promise, other structures provision of the policy, contained a standard business pursuits exclusion which excluded loss to property, quote, used in whole or in part for business purposes or used to store business property. It was undisputed that Mr. Scafella's then fiancée, Miss Lisa Smith, obtained 2 insurance quotes from Erie for the property, one including an incidental farming endorsement and one without the endorsement. Ultimately, Mr. Scafella chose the insurance quote that did not include the incidental farming endorsement, a less costly option. It is further undisputed that in completing his application for insurance with Erie for the property at issue, Mr. Scafella averred that there were no farm animals or pets on the premises and that he did not conduct, quote, any business or occupational pursuits at the premises, close quote. The court noted that it is really not nice to lie to your insurance company when buying a policy, and despite indicating to the contrary in his application for insurance, evidence showed that Mr. Scafella does not deny that after taking possession of the property, he began operating a business out of the milk house. That business, Olivia's LLC, was a retail store selling meat, cheese, and sandwiches. Prior to the fire, Mr. Scafella alleges that he had begun to renovate the large barn structure into a catering hall and restaurant to be known as Sophie's Serendipity, LLC, as part of his plan to develop the farm into a destination wedding venue. There is no question that the February 2, 2019 fire caused significant structural damage to the large barn and resulted in the loss of numerous items of Mr. Scafella's personal property which were stored in the large barn structure. Although the milk house was adjacent and physically abutted the barn, Mr. Scafella claims that it was not affected by the fire and that the origin of the fire had nothing to do with the business operations there. His claims, however, were made shortly after the fire when He sought coverage from Erie for the loss. Property adjuster Stanley Geho was assigned by Erie to handle the claim. As part of his investigation, Mr. Geho visited the fire-damaged property and drew a diagram that depicted the milk house as an addition to the barn structure, with an interior doorway connecting the two areas. Mr. Geho's depiction of the premises was consistent with a statement made by Ms. Smith, who, during the recorded statement taken by Mr. Geho, described Olivia's as being, quote, in a different part of the barn building, close quote, but in the barn itself. Erie denied the portion of the fire loss claim for the structure of the large barn under the business pursuits exclusion of the other structures provision of the policy, as Mr. Scafella was operating a business, Olivia's, out of the structure. The circuit court found that the milk house and the barn are one structure, close quote, and the court concluded that the evidence on the record did not support Mr. Scafella's claims. The Court of Appeals concluded that Mr. Scafella failed to meet his burden to establish waiver, which he claimed as an excuse for not providing the extra coverages he wanted, and the Court of Appeals found no error in the Circuit Court's award of summary judgment to Erie and Mr. Geho. The Court of Appeals concluded that the large barn area where the fire occurred and the milk house where Mr. Scafella operated Olivia's are the same structure. In fact, when providing a recorded statement to Erie, Ms. Smith identified the barn as being part of the one building where she operated Olivia's. Claiming a clawback provision gave him coverage, Mr. Scafella represented that the property within the large barn was his personal property to collect $67,640.80 under the personal property coverage in his Erie policy, possibly to avoid the $2,500 limit to business personal property under the special limits portion of the policy. The Court of Appeal concluded that to permit Mr. Scafella to change his classification of the property at issue to recover under corresponding portions of the policy is impermissible and would allow him a windfall and coverage for which he did not pay. Finding that there was no error in the trial court's decision, the Court of Appeals affirmed that decision. In my opinion, when a person is given a choice of available coverages and chooses the one less expensive, he or she is gambling that the loss will fit into the lesser coverages and misrepresents the facts at the site of loss to obtain the less expensive coverage. The insured is committing a form of fraud. After the loss, Scafella attempted to change the policy he purchased into the policy he refused to pay for, with multiple legal machinations that the courts of West Virginia refused to honor. The moral this case teaches is that a person seeking insurance should always tell the truth to the prospective insurer and never buy a policy that does not provide coverage for the risks that the property faces. That's what Mr. Scafella did, and that's why he was not indemnified. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. And you can subscribe to the blog and will be notified of every blog posting, which will usually be 5 or 6 a week, and will also allow you access to the more than 4,650 blog postings. You can also subscribe to the videos on YouTube or on rumble.com, and that will give you access to hundreds of videos. all of which are free. And if you do, I'd appreciate it if you click on the like button at YouTube or the thumbs up button at rumble.com. Please tell your friends and colleagues about the blog and the videos, and let them also subscribe to the blog and the videos. And if you're interested in more detail about insurance, insurance law, insurance fraud, insurance claims, please consider subscribing for a very small fee to my Substack publication or my locals community. Thank you for your attention.